All right, I'm going to call this meeting of the Plan Commission to order. Could I have a roll call when you're ready?
Mr. Ackerson?
Present.
Mr. Fell?
Here.
Mr. Fitch?
Here.
Mr. Hopkins?
Here.
Mr. Otto? Mr. Storr?
Here.
Mr. Trail?
Here.
And Mr. Turner?
Here.
We do have a quorum. Are there any changes to the agenda?
No, but maybe it'd be helpful to point out that one of the members is sitting in the audience in case they are curious as to the roll call versus what they see.
That is correct. One of our members is ill, and since he is present, but he'll be sitting in the audience, we don't anticipate there will be a vote on anything tonight, so should be fine. Approval of the minutes. Everybody got the minutes? Motion by Mr. Fell. Mr. Ackerson, second. Any changes to the minutes? In that case, we'll have a voice vote on the minutes. All those in favor of approving the minutes, say aye. Aye. Those opposed? The minutes are approved. Do we have any communications? I'm not sure if you want to address this proposed ordinance now or later.
We can mention it during the staff report.
Okay, great. No continued public hearings, no old business, no new public hearings, no new business, no audience participation. We do have a staff report. Proposed revisions to right-of-way ordinance regarding telecommunication facilities. In connection with said staff report, we had an article from Zoning Practice Magazine regarding recent trends in the telecommunications industry involving public rights-of-way. So now we have a staff report, so if you could introduce yourself to the TV audience.
I think actually Lori has a
Lori's
couple
going to
things.
start off.
I just wanted to provide a little context. We did send that zoning practice to you, and Brad Bennett, the assistant city engineer, is here to talk a bit about some proposed revisions to the right-of-way ordinance to address the anticipated requests that we will have for this kind of facility in the right-of-way. The Plan Commission does not have any jurisdiction over the right-of-way ordinance, but we do know that you're all really interested in this kind of thing. So we thought it was good to bring this to you. It's slated to go to Council, Committee of the Whole. So this also provides you a little opportunity to review the text prior to that, in case you wanted to weigh in, provide any comment, that kind of thing. So,
Great, thank you. Mr. Bennett?
Thank you. I appreciate being able to come tonight to speak to you. Give you a little background. The Chapter 20, which relates to all the items in the right-of-way, which is, everything from utilities, fiber optic, water mains, sewers. It covers driveway approaches, sidewalks. So, it covers a great number of things. I'd say the primary focus is usually utility related. The city had adopted a right-of-way ordinance based on the Illinois Municipal League Model Ordinance back in 2014. Our ordinance is very similar to Champaign's. We coordinated with them to ensure a certain level of kind of continuity between the communities. But amazingly, back in 2014, the ordinance that we adopted at the time did not anticipate the small cell technology and the concept of locating essentially cell towers in the public right-of-way. The traditional model for the cell phone system that we had seen up to that point was, large towers located on private property that the cell phones, communicated with, and then some sort of fiber optic relay or micro relay off of the the cell towers back to some sort of central switching station that the telecommunications companies operated. So what this new smart cell technology is, and I have a limited understanding of it, so I'm by no means an expert in this, but essentially they're looking at trying to expand the capacity of the bandwidth with so many people with mobile devices. I know my 14-year-old carries 4 devices with him at all time that can connect up to the Wi-Fi. So apparently we as a society are using up an enormous amount of bandwidth. So the idea is to have lots of small little towers that essentially allow this backhaul or feedback of the lines to the switching facility, and apparently that allows them to increase the bandwidth capacity. So, you know, these small little towers typically are an antenna attached to a pole, and they typically have a range of like 30 to, you know, maybe a couple thousand feet. Obviously depends upon what the height of the antenna is and some other variables there. And you can see on this graphic, this is just kind of an example I pulled off the internet of what this small cell technology is. So if you look at this, you can see in this particular example, they're showing the antennas are mounted on city street lighting poles. They could be mounted on other existing utility poles. They could be put on utility poles by themselves, but they essentially collect a portion of the cell phone calls and then relay those back to the big towers, which ultimately gets fed back into the switching system. So the reason we're looking at revisions to our right-of-way ordinance is we had a company called, and I think it's pronounced Mobility, though we're not 100% sure. It's kind of a funky spelling of their company name. But this is a company that essentially installs telecommunications infrastructure and then rents or leases those facilities to different telecommunication providers. So Mobility approached the city about installing some of these personal wireless facilities in the city of right-of-way. In particular, on November 4th, 2016, they applied for special use permits to install some 70-foot tall monopoles, which I'll show you a graphic of what that looks like. Essentially a big utility pole that would have their telecommunications antennas on it at 3 locations in the city right-of-way, along with a 4th one in IDOT's right-of-way up on University Avenue. So what they were proposing to do is, I apologize, it's kind of hard to read this graphic, but this is a 75-foot tall pole that would be kind of their typical installation. You can see at the very top of it is the telecommunications antenna that usually sticks, you know, I would say between, you know, 3 to 5 feet above the top of the pole. And then you'd have to go all the way down to about 10 foot above the ground level where most of the wiring and metering and you know, kind of the base equipment is located. To give you an idea, these poles would be embedded about 10.5 feet deep in the ground in order to support them. They'd be roughly about 18 inches in diameter where they come out of the ground, and they taper to probably about 8-inch diameter up at the top of the pole. So these are fairly significant structures, you know, that we currently do not have anything like this in our right-of-way. And we think one of the reasons that the telecommunication companies are doing this is they feel that they can jump through less hoops to get these installed in right-of-way than negotiating with private property owners like they traditionally have to acquire property rights to install their towers on private property. So we've checked and done our due diligence of finding out what our neighboring communities have done, and this is just kind of a summary of what some of the other municipalities around us have responded to this. You know, we're not the only community that's had this request for these towers. You can see all the communities listed here. We've contacted and confirmed. I suspect there's even more communities out there that have been contacted by this Mobility about putting in these personal wireless telecommunications facilities. But for example, Champaign looked at revising their right-of-way ordinance to regulate the placement of these devices in the right-of-way. Same thing with Wheaton, Evanston. Danville and Rantoul, they just outright rejected the permit applications and said they won't allow any poles in the right-of-way. In conference with our legal staff here, we don't think that's a real defensible position. Federal and state law guarantees telecommunication companies certain rights within the right-of-way. We feel that we do have some ability to regulate them, which is why Champaign, Wheaton, and Evanston all made changes to their ordinance to better regulate these type of things rather than just trying to deny them. And then the one that's kind of taking a wait-and-see approach that we contacted was Normal, Illinois, where they've received the request for the installation, but to date, they haven't issued an approval of any permits, and they're evaluating their options as far as how to respond for the request to locate those facilities. So, in trying to protect the public right-of-way as well as people's private property rights, city staff is looking at making some revisions to the right-of-way ordinance. Like I said, we can't necessarily prevent them from locating facilities within the public right-of-way based on current federal and state regulations, but we can, essentially control how and where those facilities are installed. So some of the things we're looking at proposing that we feel would be in the best interest of our public would be to limit the installation of the towers to only occurring on existing utility poles, rather than allowing them to construct these new 75-foot tall poles in the public right-of-way. They'd have to put on existing, either power or telephone poles or city street lights or traffic signals, some sort of existing pole within the right-of-way. We look at limiting the location to arterial streets. Those have a tendency to have the wider right-of-ways that would better accommodate having these facilities in them. We look at limiting the height of the antenna and related equipment to no higher than 5 foot above the top of the utility pole. Once again, this is aimed at controlling the height that these things would stick up in the air and potentially, create either safety issues or be aesthetically unpleasing. Limiting the size and related equipment for that facility. If you remember back to that drawing, there's a bunch of equipment that gets attached to the pole as well. Limiting that all to 5 square feet of surface area. Once again, trying to limit the visual impact of said facilities. Require that no more than one antenna can be placed on a utility pole, and that antennas must be at least 300 feet apart. We don't want one every 25 feet located in the public right-of-way. First of all, the poles, typically existing utility poles, aren't spaced that close together. And then require written permission to be obtained from the utility owning the poles where the antennas and related equipment are proposed to be installed. So all the utility poles that carry telephone, cable, power are generally owned by Ameren or AT&T here in Urbana. So if Mobility wanted to install it on existing poles, they would have to come up with some sort of license agreement or some sort of agreement with Ameren and AT&T, depending upon who owned the particular pole, and get their agreement and approval to do that. The same thing would be said if they wanted to install it on a city infrastructure item like a city street lighting or a city traffic signal pole. They would have to have some sort of written agreement with us that would give them permission and set some conditions for said infrastructure to be installed. So, and then kind of an unrelated item, so this isn't related to the cell towers in the public right-of-way, but council had asked us to streamline the license agreement process. Right now, it currently has to go through council for approval of any license agreement. So we're looking at, for underground utilities, allowing the mayor to be able to approve those without it having to go to council, which would expedite the process and allow utilities to get license agreements in a quicker time frame. So with that, I'll kind of open it up to questions.
I assume we have no control over what happens on a, say, an Ameren pole, but if they want to put one on a city pole, do they lease that? Do they pay for it? Do we just give it to them?
Well, they would have to have a license agreement with the city. We currently have a process set out in the ordinance. For example, and I mean, this applies not only to utilities, but any business that would want to install something permanent in the public right-of-way. We recently had the 25 O'Clock Brewery wanted to create a patio portion within the right-of-way. So there is a process you can go through. A license agreement is created. And the license agreement states, what the term of it is, what the conditions are. So, Mobility could go through a similar process if they wanted to locate it on a streetlight. But, the agreement would set the conditions as far as how high above the pole, how it was attached, all the specifics. There'd probably be some indemnity, requirements to reduce our risk. So, yeah, I mean, it would be possible for them to do that, but there would have to be a specific agreement created that was agreeable to the city.
I'd assume similar to other things, if their antenna becomes obsolete, they have to get rid of it.
Yes,
that
there's
they're
always a clause in the license agreements, or if it's just unused for a period of time, they have to remove it at their cost.
Further questions for Mr. Bennett? Mr.
I
Trail?
have a bunch.
And Mr.
But
Trail?
also,
Yeah.
I'll just wait.
It might be your turn. Any more, Mr.
Audience participation.
Audience?
Brad, is there any particular, since they may want to strap these on or bolt them to some of these utilities, is there some sort of a safety sort of thing that they need to go through to make sure that these are secure so that in such a way that if there's like a vehicle hits a utility pole that it doesn't snap it off and become kind of an airborne missile or something?
Mr. Storr asked about safety precautions that apply to these additions to the pole.
Well, yeah, the existing utility poles have to be a certain distance back from the street, you know, and that's one of the safety features we have. Generally, with these wooden poles, there is no breakaway feature. Like some of our traffic signal poles and streetlight poles, which are typically located real close to the curb line, they're actually designed, the foundation is designed to break away so that it lessens the impact of a car on it. But for these particular, the wooden pole facilities, there really isn't any sort of breakaway feature. As, part of the agreement with either Ameren or if it was for our own infrastructure, I would assume there would be some sort of safety analysis and requirements as far as attaching it to the pole to make sure it didn't overload the structural capacity of the pole and there weren't any issues with it getting blown off in the wind. So there would have to be some sort of analysis and certification that they were indeed safe.
As I recall, the article we had showed also these little metal boxes appearing in the right of way, and all I've heard about so far are poles. Is there any possibility that these little boxes will start showing up in the right of way? Because there could be tremendous public pushback if every few blocks people start seeing these metallic boxes in the right of way and they don't have any say-so over that. So I don't know if that's also in the works, if it's only likely that poles are going to come into effect.
I mean, it's possible that there could be some sort of boxes with what they've submitted so far, which is pretty preliminary. I mean, you saw the level of detail what we've gotten so far. So right now, they're not currently showing any ground level enclosures that go with it. But, it's possible if you got a different company, they might have a different technology setup that would require that. And if you remember AT&T, with their UVerse service had these boxes or enclosures that were installed within the right of way. Now, if memory serves me for that, I think the city had some screening requirements. I think they had to spend $1,500 for each one of those in landscape screening facilities. So it's possible you could work some similar thing. But what they've submitted so far doesn't show anything, but it doesn't mean that they've submitted everything to us, or if a different company came in that, they wouldn't have, the type of enclosure that you're talking about.
I think Mr. Eckerson might be talking about the ones that are not mounted at the ground, but higher on poles. Is that correct?
Well, there in the article that we had, it actually showed both. And what I'm thinking is, it sounds like you're responding to what this one company's planning on doing.
Correct.
And I'm thinking more about the emerging technology, and if you have plans for if any of these other alternatives to just putting something on a tall pole comes along.
Brad, maybe we could look at the language to see if instead of just referencing antennas every 300 feet, we reference something more general that would include that same kind of facility.
Mm-hmm. Yeah, we can take a look at that.
Thank you.
Thanks.
I think, Mr. Trail?
I have a lot of questions about this.
Okay.
I found the article odd. I'm trying to put this in the context of what the heck is going on here. Because, kind of the way things are going now, wireless providers are showing up as excellent competitors to non-performing broadband, so to speak, by the American standard providers like Comcast, who've been dragging their feet for decades. And now I got news for you. My little T-Mobile phone, I can get faster internet service on this than I can out of Comcast for my house. So, and from what, not that I've done any in-depth research on this, but my understanding is that a lot of these new technologies, the wireless providers, require lots more locations because they need more antennas. If anybody's got a newer wireless router in their house, and one with antennas, they have more and more antennas. You know, they used to have just the one. Now you buy new ones, they have more antennas. So the way they provide more bandwidth is more antennas, and you gang them all together, right? Like, you know, more, like they used to make T1s by ganging up individual phone lines. So that's why, sort of, when you look at the article, all this thing about putting them on utility poles and stuff like that, because they want lots of them. Lots of points, gang up, you know, so that in essence, you know, you're connected to multiple antennas at the same time. Not sure where these 70-foot single poles that look from the thing like they've got one monopole antenna on it. That doesn't even sound like the same thing. So I'm kind of trying to understand where this is coming from and why. Has anyone asked Mobility what the intended use of these poles are?
Yeah, I mean, it is for the small cell technology. Like I said, they're an infrastructure provider, so they will put the infrastructure in the ground and then essentially sell to like a Verizon or AT&T or T-Mobile.
Which is typically their business model. They
Yeah.
typically don't want on-the-ground infrastructure. But how do these single large poles fit into that? Are these basically microwave backhaul relays? Is that what?
I believe there is some sort of backhaul relay from the antenna, you know, back either to their main tower or to some sort of switching facility.
So I'm trying to also feel, you know, we have other providers like Ameren, et cetera, who have been allowed to place utility poles. Do these guys have the same ability to do it? Are there anything in our agreements with Ameren and AT&T that require, if their facilities in the right-of-way, like poles, that they can be used by other providers? I mean, I'm kind of trying to get, what's the situation here? Why are they wanting to build these tall, right off the bat, they want to build these really tall poles, which almost seems like the last thing they do.
Well, like I said, I think some of it is, you know, the traditional model for putting in cell towers is, you know, the cell company either purchases or leases a piece of property and installs it on the private property. Well, you know, obviously there's negotiations and costs, you know, associated with that. Then you have to come in and meet zoning requirements for the city. You know, you have to get building permits and stuff from the city. It's a very involved process. I think they've learned that if you go through the right-of-way and the utility process, you don't have to jump through all those hoops. And the way that the current federal and state regulations are written concerning telecommunications companies, we have to allow them to use the right-of-way. We cannot say no. We can regulate and just say, well, you have to meet these conditions to locate your facility in our right-of-way. But it's not like a private property owner where, you know, Mobility comes to me and says, you know, hey, I want to put my cell tower on this piece of property. And I say, no, I don't want it, you know, go away. I mean, we can't do that. So I think some of it is they're looking at what's the quickest, easiest way to get as many antennas up as we can. And, you know, they see the right-of-way as being the solution to that rather than the traditional model going through private property.
Well,
located.
their old model was voice. I mean, really, if you look at our cell infrastructure now, it was all set up for voice. But they've sort of jumped in to fill the vacuum for data. So, I don't know. I just found some of the language in this article kind of, these unnamed, nefarious, you know, people are going to show up and want to do things, but you don't have to do it. You know, it's kind of like, I don't know. It's kind of definite, got to seem to have an understated, you know, agenda here. I would like to, if you could go back through your presentation real quickly, just go back to, because I was curious where you Maybe
Was
it's
there
the
a particular
next.
part you wanted to see?
Maybe the next. No, go forward again. Okay. Where did you get these specific ideas?
They're from Evanston, or not Evanston, Wheaton's ordinance, but they're also similar to what Champaign recently adopted on Tuesday night.
Where did they get them?
Well, from Wheaton.
Where did they get them?
I think them from Evanston.
So
Well,
that's kind of my curiosity. Let's assume for a moment that Urbana felt it was in our good public policy to allow for new wireless broadband technologies to be rolled out. I mean, if nothing else, just as a competition to our current broadband situation, would these allow that? As appropriate? Because I noticed you had some very specific numbers later on, 300 feet.
Which is, I think, is a typical spacing for existing utility poles. Is
For utility poles.
yes.
Is that responsive to what they want to do? I mean,
Well, to
if
be
any
honest-
kind of pole, would you never want them closer than 300 feet?
Well, I mean, to be honest, they haven't really shared with us what their technological limitations are as far as, what a minimum height is or what a maximum spacing is. So all they've done is come to us and said, well, at these locations, we want to put 75-foot tall poles. So I don't have any information as far as what their technical capabilities
That
are.
makes me wonder where all these specific numbers came from,
Well, 300 feet is a common block length, so we
For
often, excuse me?
utility poles.
No, for city blocks, they're usually between 250, 500 feet for an older
So
town. city block.
streetlights, utility poles are always 300 feet apart.
No, I'm saying between streets, typical block width or length is 300 feet plus or minus. So it is common to call things out, one per block.
Right, but common based on what was going on 50 years ago or 40 years ago, or I'm just trying to get, I'm just trying to get at why these specific numbers. I don't know that we're supposed to have read through all of this yet. I guess this is proposed ordinance changes?
That was what was sent to council today for the committee of the whole meeting on Monday.
Who drafted these?
Brad did based on the research of the other communities that he pointed out.
Again, based on what? Wheaton and, not criticizing by any means.
Well, Champaign and Wheaton were the primary models for it.
Right. I obviously haven't had too much chance to go to it. What is, personal wireless service?
Well, that's what we're talking about, is that small cell technology.
What is personal wireless service? Is there any wireless service that isn't personal? I mean, where did the phrase come from?
I mean, that's what the people in the industry have commonly referred to it as.
And
Okay.
it does refer back to
There's a
federal
definition.
regulation.
There's a definition on.
I know, I was kind of looking, but it's kind of vague a little bit.
Yeah.
Again, I want to make sure, understand, I'm not criticizing, because I realize, honestly, I don't have any better things to tell you either. I'm just curious where this is coming from and why. And it sounds like everybody was kind of taken by surprise by these guys showing up and
You
saying they
are
want to do.
Correct, yes. And the concern is that if you do not have something in your ordinance to regulate it, that they can come in and install these facilities. So the idea is you want to enact quickly some regulations so that you have some control.
Are you saying that currently there would be no way to prevent them from erecting these poles as requested today?
Based on the current ordinance language, yes.
Well, though, in the instances where a special use permit would be required, there is that procedure which could place limitations on it. But I think the concern is that if we don't have something in the right-of-way ordinance, we could see a much different landscape than probably most people would like to see.
What's the time frame
as far as when the potential first poles could be installed, or as far as when the
Any of the above.
well, like I mentioned, we've already got the initial special use application, which was deemed incomplete. So, you know, they could choose to resubmit that at any time. It could also be that a different company could come in, you know, with a request to put these poles in place. So, I mean, it literally could happen any day. Our plan is, you know, to present this on Monday the 9th, and then hopefully by the 23rd of January, if council approves, to have the new language adopted.
I guess basically my concern is it sounds like we're doing it in a rush, and there's a fair number of specifics in here that maybe people might want to take back later on, or that may serve agendas that people don't realize. So I guess I'm not sure whether that was more question or more speech, but
Well, we are communicating with AT&T. We reached out to Ameren, AT&T, and Comcast, because those are our three big utility providers here in Urbana. Ameren really didn't have any issues with it. I mean, in fact, they've actually received an application from Mobility already over on the Champaign side to utilize some existing Ameren poles. Comcast never responded. They haven't indicated any interest, but we are communicating with AT&T. They've got some concerns and suggestions regarding the language we shared with them, and that's something that we'll be taking a look at kind of between the 9th and the 23rd to see if, you know, any of their suggestions or recommendations need to be incorporated into the ordinance.
they are obviously an interested party.
Yes. And our lawyer has been talking to their lawyer kind of thing, so, you know, they're providing us with some good input. We'll have to make the decision what, if any, parts of their input that, you know, we choose to incorporate, because obviously, you know, our interest is in protecting, you know, our citizens and property owners, not the betterment of the utility, which is what AT&T's lawyers are wanting, so.
Do we have jurisdiction over what Ameren does with their poles? I mean, could a company like this just back channel us and contract with Ameren directly to put them on every pole Ameren has? I mean, once Ameren has a pole there, does the city have a say over what goes on it?
Yeah, we do. But they also, you know, in addition to having the city's approval, they would have to have Ameren's approval.
Well, I'm sure Ameren would love to sell them a piece of every pole they have.
Yeah.
I'm sure not sell these.
Well,
Yeah, no, I think my reading of this, and it's real quick, is that an existing Ameren pole would be subject to the same restrictions as any other pole that currently exists in the right of way.
Well,
So it would have to be 300 feet apart. It could only stick 5 feet above.
Well, I guess my question is, this is sort of, I don't know if it's an unprecedented thing, but I don't know, is Ameren asked frequently, can we stick something on your pole? And
They are,
You know.
and they do have a whole program set out, how they lease out space on their poles. And to give you an example, I think Comcast has been, and their facilities are all on AT&T or Ameren poles. So they lease, you know, the line space on those poles, but they've also been installing, I think, Wi-Fi amplifiers or something on those poles to boost the Wi-Fi. If you drive around town and you look on your cell, you'll see there's a Infinity wireless network a lot of time that you can access if you're a company. So there's already been antennas installed on existing utility poles.
well, I guess my question is, the city had no say in putting that on a utility pole. Why do we have a say in this on a utility pole? Isn't it the same thing? It's just a different geometry.
Well, what we're trying to do is saying, you know, we want it to go on the existing utility poles. That's our preference, as opposed to them installing new poles to carry just the antenna.
Well, I guess the intent of my question is they could put one every 50 feet or however, you know.
Well,
Ameren-
Ameren is subject to our right-of-way regulations, so, yeah, I mean, if we specify the spacing is 300 feet, I mean, right now, there's currently nothing in the ordinance as far as addressing antennas. I mean, this would be new language, so, but, I mean, Ameren is subject to our right-of-way ordinance, so, you know, they wouldn't be able to allow one to go every 50 feet. They have to follow whatever prescribed distances we set.
Now, the thing for me is this is all infrastructure. Why would you lay down a new set of train tracks if they've got a new train company coming in, as opposed to having everybody use the same set of train tracks other than the train tracks get adjusted? If I'm using an imperfect analogy, it seems to me we don't want to see a proliferation of poles. What we'd like to see is maximum use of what's already out there, so we're not adding to the clutter, but at the same time facilitating the new infrastructure for the new technology that's coming along. We used to have telephone poles, now we've got broadband.
Yeah, that's an excellent point. Very well stated. That's what the goal of this is. Like I said, we're not trying to prevent the location of, small cell technology and right away. I mean, we're actually prohibited by the federal government from doing that, but we do want to control it because we don't think any property owner is going to want a 75-foot tall pole in front of the residence just to boost, the 4 gig network, bandwidth.
The concern I would have is if AT&T decides we don't have to prevent our poles, and then they're like, well, we got to put up new poles because the competitor won't let us do it. That would be my concern.
But is anything in this responsive to that?
Hey, that's an interesting question. It's a
I
good
mean,
question.
if you don't address that, but you prohibit people from putting new poles, you lock them out. And also, let's say this new technology really requires some kind of pole. And I really, these 70-plus feet one, I think that's backhaul. I really think that's backhaul. Big towers with, one antenna on it, that just doesn't sound like, this multi-antenna stuff. So whatever's going on, I mean, maybe with mobility, sounds like they've been obviously trying to get a lot of this, right? So
Yeah, I mean, they've contacted all the communities that were listed on an earlier table are ones that have been contacted by mobility. So they're the big player we've had to work with. We haven't had any other, I think, requests, but I mean, there could be others down the road.
Has anyone asked them what their eventual infrastructure they plan on would look like? And how these poles enable or disallow that?
well, I mean, we have met with them, but I mean, what we shared with you is all the information that we've gotten out of them. So,
Mr. Hopkins?
So I want to sort of step through the specifics that I've heard, because I haven't really found them specifically in the ordinance. If we're limiting installation to existing utility poles, where in the city of Urbana are there utility poles that are 75 feet tall?
no, they would not be able to put 75-foot tall. I mean, the existing utility poles usually aren't more than,
40.
yeah, and in fact, the light poles are typically 30 feet and under.
Yeah, okay. So this ordinance has wiped out the 75-foot pole possibility,
Correct.
correct? Okay, so we don't need to focus on that. Now, we're also limiting them to arterials.
Correct.
Since I don't have the right map, can you remind me what the arterials in Urbana are?
Well, it'd be like, Windsor, Lincoln, University, High Cross. There might be some others, but I mean, it's the
Okay.
major street classifications.
Yeah, I mean, I know what it means, I just don't
Yeah.
have the map in my head. But some of these are residential streets.
Correct. And that's where the special use out of the zoning would apply as well.
Okay, so that...
I
that-
don't think,
that-
I'm sorry, that's, maybe you and I need to talk about that because that wasn't my understanding,
Okay.
so.
Okay, I mean, I'll jump to that because that was one of my questions, though I was going in a different direction at this point. You mentioned already that they've applied for a special use permit. What triggered the requirement of that special use permit application?
I think I'll let Laura answer that one.
I'm not sure I want to get into specifics of the applications for these cases as they may come to you as public hearing cases.
Well, what I meant is what criterion in what ordinance?
The zoning ordinance.
So it's a zoning category special use permit of the kind we're used to that came into play on the specific application.
Correct.
Okay. And those would come to us. So if this ordinance is set up in a way that links to that, and apparently it does, because that is happening in a case, then the Plan Commission would in fact be reviewing some of these applications, even under this revised ordinance. Is that correct?
That's where I think Brad and I have a different understanding. So how about we put that as a question to us to figure out?
Okay.
Yeah, I think it's
So
important
done.
for us to know, I think it's important for us to understand how this does impact the work of the Plan Commission, to the extent possible.
Okay. Now, if this is small cell technology and we are limiting them to arterials, do we have any clue what limitations that puts on small cell coverage, since it seems to me to lock out? I mean, if I imagine doing the GIS operation, this does not cover the city of Urbana. Again, I don't have in my head the map of arterials, but it seems to me inconsistent with the description of the spatial distribution of the description of the technology that I'm hearing.
Well, like I mentioned earlier, I mean, we really at this point have no information as far as what their capabilities or limitations are.
But, well, okay, this goes back to what Mr. Ackerson said, that we are not trying to stop this from happening or to keep a new technology from being created. We're trying to help it happen in a good way from the perspective of Urbana. So it seems to me that we need to have from some organization, maybe an industry organization or somebody, some basic notions of spatial distance coverage, so we have some clue about where these things need to be. I have a hunch that arterials is the wrong mechanism. But let me back up from that. I understand the notion that we need to get something on the books. And my reaction is, get it on the books, and then we'll fix it.
And I think
Because-
that's a strategy that we're trying to
Right,
do.
okay, and I think you need to make that explicit. Because I'm pretty sure it's not what we want, but we want something on the books, so put it on the books. My guess is that rather than arterials, we want to use zoning categories. And I think that because some arterials are commercial, some collectors are commercial, some arterials are residential. And we also need to be thinking about spatial coverage, which we can think about in terms of zoning. And if we do it by the zoning ordinance, we can also have different specifications for different zoning categories, which may be important because we may have to have these in residential areas. So I would also suggest that we do not have time in the next 24 hours or whatever you got a little more than that, to change your draft ordinance. But maybe, again, you put it in place and we go to work fairly quickly and maybe even say to the council, we think there are longer term or probably better ways to do this, but we don't have time to get them in place right away.
Well, I mean, I think we'll have an opportunity to look at that between January 9th and the 23rd when we're
Yeah,
looking at
okay,
the
I meant before
AT&T.
January 9th, because
Yeah.
you got to present something. to
Well, I
the
think
city
we're kind of
council.
locked in because the
Materials have
council
already
packets
gone
have
out, presumably, yeah.
so-
So that's what I meant. So when you talk to them, it seems to me you could initiate this discussion at that meeting, but you can't change what you're taking to them at this point. I don't
Well,
see
and
a way to
it's
do that.
quite possible that council may have some input that they want us to look at
Oh,
incorporating
yeah,
into.
yeah.
too.
That's sort of my input. Now, another comment. From reading the document you shared, one of the comments was that the extent of fiber optic coverage would affect the placement and necessity of density of these.
Mhm.
And in some neighborhoods, based on ITV3 and whatever the state of that is at the moment, and I don't think it's good, but I don't know what it is. I've got fiber optic in my backyard, both literally feeding trunk and into my house. But that implies, as I understand it, that could be linked into easily in the neighborhoods where it exists for these small cell units.
Well, and like I said, I can only speak to what Mobility has submitted, but I don't think any of their facilities actually connect in with any of the fiber optic network. There is a power connection off the power grid that feeds their antenna, but all the installation drawings I've seen don't show any sort of fiber optic, connection from the
Okay,
antenna
I'm going
itself.
on what I read in that
Yeah.
document.
That article.
So I think he's saying
And I-
it's possible.
And
It's
I think I'm
possible.
in part suggesting that perhaps, at least in some neighborhoods, we have more dense fiber optic service
Mhm.
than the typical community or the typical industry standard writer assumes, and that some of these things therefore might be accomplished in different ways here. I don't know. I'm picking up on that suggestion. Then one additional thing. This focuses on the city right-of-way,
Mhm.
where Ameren, AT&T, whatever agglomerations of these, have rights-of-way that are not parallel to streets, as in my neighborhood. Those are not city rights-of-way, am I correct?
Yeah, those are easements. You're talking about back lot or side lot
They're
easements.
easements, but they are not city easements, are they, or are they?
Well, it all depends how a particular easement was written. In a lot of the older areas, they're general utility easements, so you're correct. They're not
Okay.
that the city
So-
controls them.
This ordinance is written to apply only to city rights-of-way,
Correct.
by definition.
Yes. It would not apply to easements.
And do we know what the implications are for the poles in my backyard? Of which I have two within, 100 feet. And neither is in the city right-of-way.
Well, I mean, that would, go back to the language of the easement.
I understand that it would go back to the easement, but I guess what I'm saying is, we have a new expectation about facilities being put on poles.
Mm-hmm.
We are saying that we don't think we want them done without regulation in city rights-of-way. If we attach this to the zoning ordinance instead of to right-of-way ordinance, or if we link it to the zoning ordinance instead of thinking of arterial streets and street rights-of-way, it seems to me we can also apply to perhaps the same special use link regulations to poles that are not in the street rights-of-way. And I think that there could be as much concern about the poles in our backyards as in our front yards.
Well, if those poles in yards are just in easements, the underlying property owner, that's private property, right? So it would need to follow the rules in the zoning ordinance because it's on a piece of private property. So you'd have the setbacks, the heights, and all of the usual requirements in the zoning ordinance for cell towers. That's how I would interpret it.
Okay, but it's not a cell tower, it's a facility put on an existing tower. Or
Well, we also-
building a 75-foot tower, yes.
But we also, the zoning ordinance also has regulations for antenna, and I can check to see if it's general enough to cover
Okay.
like
So-
this
so, but
small cells and
That's
things.
what I'm suggesting. I think we want to link this, if we can, to zoning, to land use rather than streets, because I don't think it's actually about streets. I think it's about visual and solar shading and other things that happen otherwise. Okay, that's my list.
Mr. Trail?
I actually, there's two different questions. Public right-of-way is different from an easement. An easement's a contractual issue. And where it's zoned, obviously, is on top of it. You can't make an easement that's countervailing by your private agreement, you know. So it's different issues.
I understand it's
Yeah,
different
that's what I'm
issues. That's
saying.
my point. I want it to be so that it addresses them. And it can't through this ordinance.
I think they'd end
because
up
it's
being,
private
yeah, I think they'd end up being different, two sets of ordinances,
Yeah.
probably, is my guess.
Agreed. One is in zoning, one is in right-of-way.
Yeah, I looked through here in response to both of these lines of questioning, and I really only find the zoning ordinance mentioned in one place, and I don't think it applies to. I don't think it applies to these antenna that we're talking about. It says no new freestanding facility may be installed at a particular location in a right-of-way if the proposed location is not permitted by the Urbana zoning ordinance. So I don't think. I would agree with you that some explicit linkage in here.
But that's what Lori was just saying, that if they want to build a
Free-
cell tower.
sure, a new tower,
That's
yeah, a
covered
new-
in the
right,
zoning ordinance.
right. A new tower, but
Yeah.
the antenna, you're right. I don't think that link is made. But I just read it, quickly, so I could be wrong. Mr. Trail?
Question, you may not know this. Do you know in feet what the definition of small cell is?
No, I do not.
It would go to your arterials question.
Yeah, right. I mean,
Sure,
that's
I
the
think it's-
issue.
I
That's
think
the
it's good
question.
points,
We
yeah.
need the
If
spatial,
small cell is under 500 feet, that kind of means if you limit it to arterials, it might eliminate that technology. And I have absolutely no idea how small the cell has to be before it's small cell. I know currently they want big cells, as big as possible.
Yeah, two's company, three's a cell, I think is the.
Something
I think, I agree with Lou that get something in there so that you've got some control. But I think what the consensus I'm hearing is that we want to make sure that cell, personal wireless, whatever you kind of technology you call it, it doesn't get choked out in some way by a regulatory scheme that doesn't meet the industry's needs while giving the city the proper control.
Well, I mean, I guess I would point out, I mean, there are all kinds of federal and state statutes
That,
already in place.
designed for that, exactly,
To
yeah.
protect that, and actually to encourage competition among the competitors within, the wireless field. So, actually, I think more of the challenge is for us as municipalities is, controlling and regulating, balancing it, the utility gains against, the public's,
Sure, sure.
sacrifice kind of thing.
Yeah, I appreciate that. Anything further for Mr. Bennett? All right, thank you very much.
Okay, well, thank you, and if you guys have any questions or additional input, don't hesitate to shoot me an email or give me a call, or if you want to stop by the office, that's fine too.
So Monday it goes to the council as a whole for unusual discussion. What's the 23rd?
I think that's the next committee of the whole meeting after the 9th. So at the 9th, we'll present it to them. We'll probably ask them to table it to the 23rd to allow us to take a look at AT&T's feedback. That'll give us an opportunity to look into some of the, input that you've provided with us here tonight, as well as take any recommendations from council and do any additional research and revision required as part of that.
All right, thank you.
Thanks.
Okay, we don't have a study session, and therefore, I believe we are adjourned.